Subbarao garu Memorial Lecture. On behalf of the Center for Policy Studies and Visakhapatnam Public Library, it gives me an immense pleasure to extend a warm welcome to all of you to this important event. Late D.V. Subbarao garu was the founding member and served as a president of Center for Policy Studies and Visakhapatnam Public Library. If you go on saying about various roles he played by late D.V. Subbarao garu in the socio-cultural, sports and legal and other activities, right from the district level to the New Delhi, the list is very lengthy. The last D.V. Subbarao garu Memorial Lecture has been delivered by Hon'ble Justice Shri Sarasa Venkata Narayana Bhatti garu, Judge Supreme Court of India. Now I invite Honorable Justice Shri K.V.VISWANATHAN garu, former Judge High Court of Andhra Pradesh, to come and onto the dais. We are privileged to welcome Honorable Justice Shri K.V.VISWANATHAN garu, the Chief Guest for today's Memorial Lecture, onto the dais. Respected dignitaries, ladies and gentlemen, may I request everyone to raise and join me in extending a heartfelt welcome to our Chief Guest with a big applause. I request Saravani garu to present a bouquet to our Chief Guest. I request Honorable Justice K.V.VISWANATHAN garu and Justice Somyajli garu to pay respect to the memorial portrait of Shri D.V. Subbarao garu. I request Shri D.V.S.S. garu to address the gathering and introduce our Chief Guest, Justice Shri K.V.VISWANATHAN garu.
Shri Justice Viswanathan garu, Judge, Supreme Court of India, Brother Ravi Chimalapati, Judge, High Court of Andhra Pradesh, Shri Verma of the Public Library, Center for Policy Studies, and all the members of the Center for Policy Studies and the Public Library, Shri Vipin Nair, President Scora, respected members of the District Judiciary, my family, extended family, and all my brothers and sisters-in-law from the Visakhapatnam Bar Association, the Hyderabad Bar Association, Mumbai Murali Neelakantan. A warm welcome to all of you. 17th of December was my father's death anniversary according to the Shastric calendar. Yesterday, the 20th of December, was his anniversary according to the English calendar. Both were very tough days for me personally as a son. But today, one day after that 20th of December, a day which we will never forget, I'm in a much, much better frame of mind, a much better mood, largely because of the presence of Shri Justice Viswanathan and your presence. A friend, TSD Srinivas, a practicing advocate, asked me, why is it that these lectures are being organized in Visakhapatnam? I told him that something and I want to share it with you. My father, as most of you know, had an immense love for the city of Visakhapatnam. He was also equally passionate about his profession. Therefore, he wanted the city of Visakhapatnam to experience all the greats in the legal profession. With that end in mind, I think many of you would recollect, Sri Soli Surabji visited the Visakhapatnam Public Library. Sri Fali Nariman visited the Visakhapatnam Public Library and the Center for Policy Studies, and both of them spoke there. And last but not the least, when I was the president of the Bar Association, Visakhapatnam, Sri Viswanathan Garu's guru, the great KKV himself, came to Visakhapatnam. I don't know how many of you recollect that extraordinary lecture in Green Park, Visakhapatnam, where Sir was kind enough to address it. Therefore, continuing that same tradition, we were trying to keep it going. This series of lectures started with Mr. Sri Gopal Subramaniam, the learned senior counsel from New Delhi, who addressed the first memorial lecture. That has been happening since then, but for the break in the COVID. The last was by Sri Justice S.V.N. Bhatti, and today we have in our midst Sri Viswanathan. Despite my best efforts, Sri Verma has not listened to me. I said, sir, introduction of the chief guest is something I cannot do. But he said, sir, protocol demands it. Therefore, you should do it. I told him, with all my experience as a lawyer, giving an introduction of Sri Viswanathan in the brief period of time that is allotted to me is next to impossible. I can download data from the Google. I can download data from the website. I can tell you that he was an extremely busy lawyer. If you see him if you saw him in the corridors of Supreme Court, you'll be running with a big list of and ticking and running from court to court, court to court, court to court, and finishing matters. I could also tell you that he represented the high and the mighty, the best in the country. Jayalalitha was his client. The Hindu group was his client. I can go on reeling off the names. I can also tell you, incidentally, if you don't mind, sir, that he used to pay more than 10 crores of rupees per annum as tax. But I know I'll be running on the beaten track when I talk like this, because introducing him in a short span of time is, according to me, very difficult, even for traditional wordsmiths like us who are lawyers. Therefore, I'll go off the beaten track a little. And I was wondering what to do. Yesterday, one of our common friends, Mr. Narasimhan Vijayaraghavan from Madras, who writes lucid and excellent English, wrote an article. He writes about music in Chennai, and also he's an expert in MACT law. So his articles are something I read with a lot of interest. He was talking about the memory and the capability of some of the greats of the Indian bar. He was referring to Sri Vishwanath Sastry, Fali Nariman, C.K. Daftari, V.T.K. Chari, and C.K. Parasaran, and talking about their individual greatness as lawyers and the skills. And therefore, when I was reading that article, I chanced upon something which I felt would be very appropriate. And I'm quoting Mr. Vijayaraghavan. This success is cultivated brick by brick through relentless study, nightly preparation, and reverence for the profession. They read deeply, repeatedly, and reflectively. They trained their minds to respond faster than any machine. So if you replace the they with Mr. Viswanathan, he read deeply, he read repeatedly and reflectively. He trained his mind to respond faster than any machine. This, ladies and gentlemen, is in essence Sri K.V.VISWANATHAN. If you are prepared, and if I talk as a lawyer, if you are prepared in his court, it is pure bliss. If you are not prepared, you are staring down a deep abyss. It is a court where the questions are pointed, where the crux of the matter is identified within the first few minutes of the matter being taken up. And if you are prepared and you can answer, you have the easiest of the courts to argue. I still remember sitting as a lawyer when a lawyer was trying to preface a big argument about regularization of employees, and in the passing he said, Uma Devi. Your Lordship, immediately with that paragraph, they said it is a once-in-a-lifetime opportunity with some conditions. A big argument which could have continued was cut short. Later, I was arguing a case for a police constable. Verification of antecedents is a big issue in the police department. This was a case of a young man who was accused of a murder. You look into the FIR and the charge sheet, his name was not mentioned. He, along with others, beat him up, that's all. But ultimately, the offense was under 302. No overt act was attributed to him, nothing. Although he was acquitted. Although the High Court directed him to to be taken into service. The state came in appeal and said, offense involving moral turpitude, therefore we cannot take him into service. At that point of time, I chanced upon a decision rendered by a lordship. It started with the words, this vexed question has surfaced again. Despite the law on the subject, a judgment that started with the line, this vexed question has started again. And to help all of us, the lordship analyzed that man's character and gave a tabular statement at the very end. When was he accused? Were there any subsequent crimes? Is moral turpitude? All we had to do was point out, my lord, please see the similarities between that case and this case. And today, that boy is working in the police department. Therefore, for all of us, I think all my colleagues who have come from the Supreme Court will agree. If you are prepared, it is pure bliss. If not, it is a deep abyss. With these few words, ladies and gentlemen, with a deep sense of pride, I introduce Shri Viswanathan.
Thank you, Somyajli Garu, for the remarks and introducing the chief guest. I request Honorable Justice Shri K.V.VISWANATHAN Garu to kindly accept a small felicitation. I request Mrs. Somyajli Garu also to join in felicitating our chief guest. I request our Honorable Justice Shri K.V.VISWANATHAN Garu to kindly deliver the D.V. Subbarao Garu Memorial Lectures.
Honorable Justice Retired D.V.S.S. Somyajulu, the illustrious son of the late Shri D.V. Subbarao, members of the family of late Shri D.V. Subbarao, distinguished judicial officers, members of the tribunal, Mr. Vipin Naya, President of the Supreme Court Advocates on Record Association, Mr. P.B. Suresh, Senior Advocate from Delhi, Mr. Patabi, Senior Advocate from Hyderabad, and other members, Senior Advocates from outside of Visakhapatnam, distinguished members of the Visakhapatnam Bar, ladies and gentlemen, a very good morning to you. It is my absolute privilege and an unique honor to be invited to deliver the 11th late Shri D.V. Subbarao Memorial Lecture. My recollections of Subbarao Garu goes back to the early 90s in the Supreme Court. I have seen him, seen a distinguished member of the Visakhapatnam Bar so frequently come to Delhi, seen him in the Supreme Court. But the closest interaction came when in the Salem Bar Association case, when the validity of the provisions of the Civil Procedure Code amendments of 1999 and 2002 were challenged. The court wanted the assistance of Shri Subbarao, his expertise in the subject, to look into the amendments and to advise the court by the way of a report, which he and the other committee members ultimately gave it to the court, and that formed the basis of the judgment. That was the respect the Supreme Court held for him. But what is remarkable about Shri Subbarao is not his exploits as a lawyer, not the vast clientele he had, certainly not the income tax he paid, but the large amount of service that he gave back to society. And that, I think, is unparalleled. There is not a field of activity in which he has not left his imprimatur. Just savor a few. He was a distinguished member of the Bar. He was chairman of the Bar Council of India. From the Mofussil Bar to be chairman of the Bar Council of India is itself phenomenal. He was the mayor of Visakhapatnam. He founded the Center for Policy Studies and was associated with the Visakhapatnam Library. He spent considerable time for the development of art and culture. But his stamp is also felt on the field of cricket. He was vice president of the Board of Control for Cricket in India, President Andhra Cricket Association, member of the BCCI, in a tour that the Indian team made in 1997, and I am not going by Google or Wikipedia. As a cricket follower, I remember him being the manager of the Indian team, and that must have been a really disciplined team. 3 months under the tutelage of Mr. Subbarao, vegetarian team. So this is, someone who has had a mark on the different facets of life. And civic consciousness was one of it. And that is why, ladies and gentlemen, that the topic that has been chosen is of importance. But I must also congratulate the family for organizing these lectures. And I say this not because I am speaking, but this will help perpetuate the memory of a legend. It will inspire youngsters in the audience. It will inspire youngsters who are watching to equal, if not emulate, a personality of that stature. That is why the topic, Constitution through an Environmental Prism, Issues and Solutions for Reversing Climate Change, becomes very important. On 23rd July 2025, the International Court of Justice delivered a unanimous advisory opinion in response to queries put to it by the UN General Assembly on the obligations of states under international law to ensure the protection of the climate system. The ICJ listed a detailed set of obligations to be honored by the states, but added in an important paragraph the role that each one of us have in this endeavor. And I quote, however, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving the problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting and satisfactory solution requires human will and wisdom. at the individual, social, and political level to change our habits, comforts, and the current way of life in order to secure a future for ourselves and those who are yet to come. Through this opinion, the court participates in the activities of the United Nations and the international community represented in that body with the hope that its conclusions will allow the law to inform and guide social and political action to address the ongoing climate crisis. So, whether you are a lawyer, engineer, architect, doctor, citizen, all of us have a role in this process. And that is what this paragraph brings about. And it cannot be achieved only by the government, only by the courts, or only by law. But we need to trace the history of the growth of environmental law before we focus on the constitutional dimensions of it, and before we address on climate change. What is climate change? Not that you don't know of, but the technical aspects of it. How is the international community looking at it? And since you have also desired that some solutions be suggested, there's an attempt made to walk you down to all of this. Each winter, our capital city skies thicken and the air we breathe turns hostile. Schools close, hospitals see spikes in respiratory illness, and livelihoods, particularly of the most vulnerable, the elderly and the children, are disrupted. We are periodically given this harsh reminder of the palpable environmental effects of our actions. But this is not new to humans. The English word smog was coined in 1905 to describe London's combination of natural fog and coal smoke. In the early days, the international community was not fully conscious of the need for collective action to protect our natural environment. However, in the decades leading up to the 1972 Stockholm Conference, the world witnessed a dramatic shift in its outlook towards the environment as rapid post-war industrialization brought severe pollution, ecological disasters, and global health crisis, prompting scientists, leaders, and citizens to recognize that environmental issues knew no national boundaries. There's a lot of debate on Swadeshi jurisprudence, and occasion to speak of it day before yesterday. Swadeshi jurisprudence is not keeping off light from all sources. It is assimilating all of them, but not having a slavish adherence, adapting it to our needs, our social milieu, our constitutional texts. That is the spirit in which we need to understand that concept also. The Trail Smelter Arbitration was a landmark international environmental law case between the United States and Canada. I'm trying to illustrate it by cases because we will then know what actually went behind the awareness towards environment. How initially it was just reactionary before we started adopting preventive measures. The Trail Smelter Arbitration arose after a Canadian smelter in Trail in British Columbia released sulfur dioxide fumes that drifted across the border and damaged crops, forests, and property in Washington state in the United States. When diplomatic negotiations failed, the two countries submitted the dispute to an arbitral tribunal, which ruled that no state has the right to use its territory in a way that causes serious injury to another state, a principle that became foundational in international environmental law. The tribunal ordered Canada to pay compensation, control emissions, and prevent future harm, establishing the enduring doctrine of transboundary harm and a precedent for state responsibility in pollution cases. At the time, there existed no international law that dealt with air pollution. In England, go back to that smog, it was only after a 4-day smog in 1952 that killed roughly 4,000 Londoners that any real reform was undertaken. the Parliament enacted the Clean Air Act there in 1956, which was the beginning of serious air pollution reform in England. Along with globalization, a global environmental movement was sparked. Scientific studies warned of population growth, resource depletion, and planet's limited capacity to absorb damage. Developing nations began highlighting how poverty and environmental degradation were deeply connected, calling for a balance between development and ecological protection. At the same time, the United Nations increasingly engaged with issues such as ocean pollution and nuclear testing, creating momentum for coordinated global action. With Sweden taking the lead in proposing an international summit, these forces together paved the way for the historic Stockholm Conference, the world's first major effort to forge a shared vision for protecting our planet and shaping international environmental governance. Our nation, India's active participation in the conference, emphasized that environmental protection and economic development must go together, compelling wealthier nations to acknowledge their historical responsibility for environmental damage. Principle 1 of the Stockholm Declaration, the key output of the conference, read as follows: Man has the fundamental right to freedom, equality, and adequate conditions of life in an environmental of equality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations. The Stockholm Conference of 72 led to India first enacting the Wildlife Protection Act of 1972. That's how we really began. Environmental Protection Act came as late as 1986, but there were some developments in between, and it's important to locate them and trace them regarding the alarming decline of the species of the tiger, because flora and fauna are essential attributes of environment. The Water Prevention and Control of Pollution Act 1974 was enacted in response to the rapid pollution of rivers, lakes, and groundwater caused by unregulated industrial discharge, urban sewage, and agricultural runoff in post-independence India. The subjects of forest and protection of wild animals were originally in the state list. They were, by enactment of the 42nd Amendment and the insertion of entries 17 capital A and capital B, brought to the concurrent list. This indicates the felt necessity of the time of the national importance of protecting the natural environment and the need for pan-India effort to protect the environment and endangered species in our forests. Around the same time, a committee was constituted under the chairmanship of Shri Singh, and this led to the incorporation of Part 4A in the Constitution, dealing with fundamental duties, a chapter which is of primordial importance but often forgotten. Relevant to the topic of our discussion today is Article 51A, bracket G, which outlines the duty of citizens to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. So slowly the awareness is creeping in, as you see. Legislations were on the anvil, constitutional amendments started to come. In a talk delivered before the commencement of the Lok Sabha debate on the bill to introduce fundamental duties, Dr. V.K.R.V. Rao, a leading scholar and member of the Lok Sabha, a former minister, suggested some additions to the list of fundamental duties proposed by the Singh committee. These additions included the human being's duty to nature and environment by avoiding spoliation, pollution, and ecological imbalance. Dr. Rao acknowledged that this is a duty to nature and, I suppose, to the environment rather than to fellow men. In other words, this would be a different type of fundamental duty. At the same time, he observed, but we all know this is becoming increasingly important for the preservation of human life and happiness in the modern world. Ultimately, 51AG was incorporated. Several Lok Sabha members also welcomed the insertion of Part 14A, in the Constitution drawing on the correlation between rights and duties. Because every right jurisprudentially has, most of the rights have correlative duties. But what was the constitutional right that was correlative to the fundamental duty? And that is a subject or idea core to our topic today. It is well recognized that Constitution was always meant to be an organic document that is alive to the needs and developments of the society, and the horizons of constitutional law are ever expanding. The texts are not fossilized beings. It has to keep pace with the times. And that is, as it was famously said, when a court interprets the Constitution, it is the Constitution that they are expounding. In the celebrated judgment in K.V.VISWANATHAN Bharati, our Supreme Court, speaking through Justices Shalath and Grover, recognized, a quote, Constitution is expected to endure for a long time. Therefore, it must necessarily be elastic. It is not possible to place the society in a straitjacket. The society grows, its requirements change. The Constitution and the laws may have to be changed to suit those needs. No single generation can bind the course of the generation to come. Through a series of landmark judgments, our Supreme Court has creatively interpreted Article 21, which guarantees the right to life to include the right to a clean and healthy environment. It is not my endeavor today to walk you through those judgments. They are all well established. The doctrines are well established. Today there is a need to recalibrate some of those doctrines. But some of those cases which were crucial, and one or two which came at a time before the enactment of the Environment Protection Act, require to be mentioned. One of the earliest cases in this regard was of the year 1980. Justice Krishna Iyer, in Municipal Council of Ratlam versus Vardichand, was faced with a situation where he had no Environment Protection Act, there was no acts regulating abatement of nuisance, but he found a provision in the CRPC, the Code of Criminal Procedure, Section 133, dealing with abatement of nuisance, and with his creativity, with his genius, he built principles around it. The Supreme Court dealt with the problem of open drains, overflowing sewage, and public nuisance caused by the failure by the Ratlam Municipal Council to provide basic sanitation. Local residents had approached the local subdivisional magistrate to take action to abate the nuisance by ordering the municipality to construct drain pipes with flow of water to wash the filth and stop the stench. In deciding the appeal filed by the municipal council, the court observed as follows, and look at these powerful words. Public nuisance because of pollutants being discharged by big factories to the detriment of the poorer section is a challenge to the social justice component of the rule of law. Likewise, the grievous failure of local authorities to provide the basic amenity of public conveniences drives the miserable slum dwellers to ease in the streets on the sly for a time and openly thereafter, because under nature's pressure, bashfulness becomes a luxury and dignity a difficult art. A responsible municipal council constituted for the precise purpose of preserving public health and providing better finances cannot run away from its principal duty by pleading financial inability. Decency and dignity are non-negotiable facets of human rights and are a first charge on local self-governing bodies. Similarly, providing drainage systems, not pompous and attractive, but in working condition and sufficient to meet the needs of the people, cannot be evaded if the municipality is to justify its existence. Now, this created awareness, led to the Environment Protection Act in 1986, but before that, we'll have to mention the Bhopal gas tragedy. Also, the municipal solid waste management rules came in 2000, etc. The Bhopal gas tragedy of 1984. So this Vardichand happens in 80. The Bhopal gas tragedy happens on 4th December 1984, if my memory serves me right, which can be described as the world's worst industrial disaster, killing thousands, gave us the tragic realization of the absence of adequate environmental and industrial safety laws in India. The tragedy became a turning point, directly triggering major legal reform, including the enactment of the Environment Protection Act of 1986. As an umbrella law, the Public Liability Insurance Act 1991 came later, and the National Green Tribunal Act 2010 came thereafter. Not long after the Bhopal gas tragedy in December 1985, oleum gas escaped from a factory in New Delhi, which stood dangerously close to residential areas and schools, injuring citizens and claiming one life. Deciding a writ petition under Article 32, moved by MC Mehta, and one must pay tribute to these individuals in these lectures. When Mr. MC Mehta used to passionately do those cases, I'm sure Mr. Vipin and Mr. Mehta, Mr. Suresh would remember, some of us would wonder, why is he doing so passionately a subject which was not fancy then? But he would day after day come and knock the doors of the court. His rulings led to several doctrines being formulated. And these individuals need to be recognized, because only today you realize that but for their efforts, we would be worse off than what we are now. Mr. M.C. Mehta, the lawyer of the Supreme Court, moved the court, and the court laid down the doctrine of absolute liability for enterprises engaged in hazardous activities, strict, non-delegable, and unmitigated by exceptions. The case reshaped Indian tort and environmental jurisprudence, affirming that in a constitutional order, industrial development must be subordinated to the fundamental right to life under Article 21. The Environment Protection Act is a significant step because it marks India's shift from fragmented sector-specific environmental laws to a comprehensive and preventive legal framework for environmental protection. It empowered the central government with wide-ranging authority to set environmental standards, regulate hazardous industries, control pollution, and take immediate action in environmental emergencies. Most of India's modern environmental regulations, such as environmental impact assessment, they came by several notifications from the early 90s, 2006, 2011, etc. Hazardous waste management and coastal regulation zone flow from this act, making it the backbone of India's environmental governance. It was in the year 1991, in Subhash Kumar's case, that our Supreme Court for the first time clearly articulated the right of enjoyment of pollution-free water and air for full enjoyment of life is included in Article 21. Incidentally, this ruling came while dismissing a writ petition under Article 32 for lack of bona fides, after finding that the petitioner was a business rival of the respondent industry and was attempting to misuse Article 32. Regardless of that, the principle laid down became a cornerstone of Indian environmental jurisprudence and firmly established the right to a clean environment. Today, even if business rivals come or motivated people come, the Supreme Court has evolved a principle that he will be removed from the case, but we will have an amicus to address the larger issue of environment, and that is a salutary pronouncement too. This principle was first taken further in Virender Gaur, where the Supreme Court dealt with the issue of a municipal authority allowing construction on the land reserved for a park. What seemed to be a local dispute in Haryana exposed a larger constitutional concern. The court treated the issue not as a question of land use, but as one of human dignity and environmental balance. Anchoring its reasoning in Article 21, the court held the right to life includes the right to a clean and healthy environment, encompassing ecological preservation, sanitation, and spaces meant for collective and cultural needs. The judgment reinforced that the state holds lands in trust for community, and the environment protection is inseparable from constitutional governance. Around the same time, in the mid-90s, tanneries along the Palar River in Tamil Nadu discharged untreated effluents. Fertile land turned barren, and groundwaters became toxic, silently eroding the lives of thousands. In Vellore Citizens, Supreme Court firmly embedded the precautionary principle and the polluter pays principle. All of us are well known to the legal community. The other MC Mehta case, the MC Mehta versus Kamal Nath, is seminal because the course of a natural river was shifted to favor a motel so that the motel becomes more attractive. Supreme Court dealt with the misuse of government power that allowed a private motel to divert the natural flow of the Beas River in Himachal Pradesh for commercial gain. Though all this highlights the roles individuals and those in power need to play to protect the environment. The court held that rivers, forests and natural resources are held by the state in trust for the public and cannot be transferred or exploited for private interests. Applying the public trust doctrine, for the first time in India, court ruled that such ecological damage violated the principal's right to a healthy environment under Article 21. All this is well known, but our other core area today is climate change. Now, what is this climate change? We experience it in different forms. Sometimes you have extreme rains. You have had floods in Visakhapatnam. We have had hurricanes here. We have had unseasonal rains. You have floodings in Chennai. You have had extreme weathers. Suddenly, off late, people have been talking about it. Moving more specifically to the subject of climate change, it is important to understand that while most environmental problems like air pollution, water pollution, or deforestation are often local or regional and immediately visible, climate change results from the gradual accumulation of greenhouse gases over decades. Now, how does this happen? It is largely driven by our dependence on burning fossil fuel like coal, oil, and gas. When we burn these fuels, they release greenhouse gases, especially carbon dioxide. These gases act like a blanket around the earth, trapping the sun's heat and causing our planet to warm. That's why you suddenly hear glaciers melting and all the other adverse consequences which happen. We will deal with some of them a little later. As pithily put by the International Court of Justice in its recent opinion, issues relating to climate change concern an existential problem of planetary proportions that imperils all forms of life and very health of our planet. They say as early as 2030, if left unchecked, temperatures could rise to levels which can make existence itself a serious problem. Therefore, responsibility is shared across nations and generations, and it impacts such as rising sea levels, extreme weather, and food insecurity unfold over time and across borders. The good news is we can still act. By reducing our reliance on fossil fuels and transitioning to cleaner energy sources like wind and solar power, we can slow down climate change and protect our planet for future generations. In a series of UN reports of the United Nations, thousands of scientists and government reviewers agreed that limiting global temperature rise to no more than 1.5 degrees Celsius would help us to avoid the worst climate impacts and maintain a livable climate. This is a real existential problem. Problem is some of them, since it is intangible, you don't realize it. Somebody hits you, it is tangible. You want to act immediately. But the slow effect it has, the adversarial effects it has, since we are not immediately grappling with it, the reaction perhaps is not as expeditious as it ought to be. How is the international community addressing it? No single nation can tackle this global challenge alone. That's why we have international treaties. First off the block was the United Nations Framework Convention on Climate Change, popularly known as the UNFCCC. It's a landmark agreement adopted in 1992 and serves as the foundation for international cooperation on climate change. It established a framework for stabilizing greenhouse gas concentrations in the atmosphere. Thereafter, in 2015, to which India is a signatory, the Paris Agreement, built upon the UNFCCC, is a legally binding agreement which came into force. It aims to limit global warming to well below 2 degrees Celsius, ideally to 1.5 degrees Celsius, compared to pre-industrial levels. The agreement outlines national commitments called nationally determined contributions. There is a national commitment which each country has to, undertake and oblige, where each country sets its own targets for reducing emissions. Additionally, it establishes a system for tracking progress and supporting developing countries in their climate efforts. These treaties are significant because they promote global action, set goals and benchmarks, and facilitate collaboration. Under the Paris Agreement, India has set out a range of commitments addressing both mitigation and adaptation to climate change. These include a target to achieve around 50% of cumulative installed electricity capacity from non-fossil fuel sources by 2030, subject to the availability of international finance and technology transfer. The commitments also refer to increased investment in sectors considered vulnerable to climate impacts, such as agriculture, water resources, the Himalayan and coastal regions, health and disaster management. In addition, India has indicated its intention to develop domestic frameworks and participate in international cooperation for the dissemination and joint development of climate-related technologies, reflecting an approach that combines energy transition, adaptation planning, and technological cooperation. So far, so good. We have these agreements, we have commitments, but are they enforceable? How is the international community looking at it? Has any litigation emerged anywhere abroad where citizens have taken industries to court or state to court and say that if this continues, the commitments cannot be honored, so abatement exercises have to be undertaken, necessary penalties have been imposed? It has already started happening around the world, and it's time we are conscious of that. In the Netherlands, in Holland, a small citizens group named the Agenda Foundation. This highlights the importance of the citizens to play a role in abating climate change, because it is an existential problem. It can no longer be left to the instrumentalities under the Constitution. Of course, they all have a duty, including the courts, but it is in each one of us, and that is what these actions highlight. Agenda Foundation, a small citizens group, took an unprecedented step by suing the Dutch state itself for failing to protect its people from slow effects of climate change. What began as a moral claim became a constitutional reckoning, as Dutch courts were asked whether government inaction could itself be unlawful. In 2019, the Dutch Supreme Court ruled that the government had a legal duty to protect its citizens and dangerous climate change, ordering it to cut greenhouse gas emissions by at least 25% by 2020 compared to 1990 levels. What made the case historic was its logic. The court said climate inaction violates basic human rights, including the right to life and to private and family life, because unchecked warming creates real and foreseeable harm. In other words, the court treated climate change not as a distant policy debate, but as a present human rights crisis, making Agenda, the group of young Dutch citizens, the first successful climate lawsuit against a national government. So if youngsters were knocking the doors of the court, the older people were not left out. Look at what happened in Switzerland. In another interesting case, a group of elderly women known as the Klimaseniorinnen, the senior women who are fighting for climate, took the Swiss state to court, arguing that rising temperatures and intensifying heat waves were not abstract climate data, but lived threats to their health and lives. What seemed like an unlikely case became historic in 2024, when the European Court of Human Rights ruled that the Switzerland violated human rights by failing to take adequate action on climate change, accepting the argument that heat waves pose a direct and disproportionate threat to older women's health and lives. The vulnerable people which we discussed at the beginning of this talk, children, women, elderly citizens. What made the decision groundbreaking was the court's recognition that governments have a positive legal duty under human rights law to protect people from climate harm. So there's a positive obligation. We will deal with positive obligation very, very soon now. And that weak or delayed climate policies can breach that duty. The judgment didn't just criticize the state, it effectively told European states that climate inaction is no longer politically inconvenient, it's legally indefensible. We are not to be left behind. Our courts have also pronounced there are two significant rulings, one as late as 19th of December, just day before yesterday, we'll deal with it. In the first M.K. Ranjit Singh case, held that we have a right to be free from the adverse effects of climate change within the ambit of Article 14 and 21 of the Constitution. So we have also started to feel this. Litigants are knocking the doors, courts are being aware, courts are pronouncing on it. Court held that the right, the Constitution of India, by holding the said right, that is the right against the adverse effects of climate change, by holding the said right to be the other side of the same coin as the right to clean environment. The first Ranjit Singh, authored by our distinguished former Chief Justice G.Y. Chandrachud, refers to our nation's commitments under the Paris Agreement to emphasize the urgent necessity to enhance our dependence on renewable energy sources. Referring to earlier Supreme Court decisions, it was observed, it is the duty of the court to give effect to international agreements and treaties to which India is a party. In an important passage, it was observed, the inability of underserved communities to adapt to climate change or cope with its effects violates the right to life as well as the right to equality. This is better understood with the help of an example. If climate change and environmental degradation lead to acute food and water shortages in a particular area, poorer communities will suffer more than the richer ones. The right to equality would undoubtedly be impacted in each of these instances. Just to give a brief genesis, because these two judgments are the ones which are, which have heralded the importance of climate change as far as our court is concerned. What happened in that case was the court was approached to protect the two endangered bird species, the great Indian bustard and the lesser florican. Both bustard species who have seen massive population decline because of habitat loss, the erection of transmission lines, solar panels and wind turbines in their flight path. The only disclaimer is, as a lawyer, I settled this application. For the power companies which were having the renewable energy power. The judgment was the result of a joint application filed by the Union government to modify the earlier directions of the court imposing restrictions on renewable energy projects in habitats of the critically endangered bird in Rajasthan and Gujarat. One of the principal grounds on which the modification was sought was that there is a need to encourage renewable energy in pursuance of our commitment to phase out the conventional source of energy, the coal-fired power plants. In 2024 decision, the court was required to balance the conservation of the bustard species with India's international obligations under the Paris Agreement and the transitioning into renewable energy. The court had to balance the two because renewable energy is also important because that's the only way of giving up coal and other forms of energy which will emit gases. At the same time, we can't give up on the environment. The court also cited Article 48A of the Directive Principles of State Policy and Article 51AG of the Fundamental Duties, which recognize the importance of the natural world in the constitutional scheme. The court directed the state to implement conservation measures for the birds and constituted a committee to monitor compliance of its directions. The Supreme Court for the first time had to move away from the usual environment versus development debate to environment versus conservation conundrum. In addressing the issue, the court stated, while balancing two equally crucial goals, the conservation of the great Indian bustard on the one hand, with the conservation of the environment as a whole on the other, necessary to adopt a holistic approach which does not sacrifice either of the two goals at the altar of the other. The delicate balance between the two aims must not be disturbed. Rather, care must be taken by all actors, including the state and the courts, to ensure that both the goals are met without compromising on either. Unlike other competing considerations, these do not exist in disjunctive silos. India's international obligations and commitments in the present case have not been enacted in domestic law. Regardless, the court must be alive to these obligations while adjudicating writ petitions which seek reliefs that may hinder these obligations from being fulfilled or otherwise interfere with India's international commitments, as well as the right to be free from the adverse effects of climate change. Now, we discussed positive obligations. When there is a legislative vacuum, court finds that there is a positive obligation in the state. Supreme Court in Vishaka, in the prevention of sexual harassment for women at the workplace, it by itself laid down some guidelines to fill in the legislative vacuum. This is a doctrine recognized internationally. Indian courts have long before, even before Vishaka, I think in the telephone tapping case, guidelines were laid down so that pending legislation, the guidelines operate to fill the vacuum, because there is an obligation in the state to enact. Because otherwise it's a discretion of the state to enact or not to enact a law. But certain laws, there's an obligation to enact, and that's the distinction. Now let's see the second Ranjit Singh ji case, which is just 2 days old. Even the ink on the paper is not dry. We saw that a committee was appointed in the first judgment, entrusted an expert committee to give a recommendation. The expert committee, after holistic scientific analysis of all the issues concerning conservation measures for the great Indian bustard and the threatened species, submitted its recommendations, which have been upheld in the recent subsequent judgment of Ranjit Singh ji dated 19/12/2025, authored by my distinguished colleagues, Honorable Justice P.S. Narasimha and Honorable Justice A.S. Chandurkar. In this judgment, the court has laid down certain important principles, several of them, but one of them is about how corporate social responsibility is also corporate environmental responsibility. The court has held that corporate social responsibility necessarily encompasses corporate environmental responsibility. It was emphasized that the CSR under Section 135 of the Companies Act, statute also has kept pace with times, makes a decisive shift from discretionary corporate philanthropy to a binding statutory obligation grounded in the understanding that corporate profits are generated within society and are therefore held in part in trust for it. In a compelling synthesis of constitutional duty and corporate law, the judgment makes it clear that social responsibility cannot be meaningfully separated from environmental responsibility. No corporation can claim legitimacy as a socially responsible actor while neglecting the environment and other beings of an ecosystem. Drawing strength from Article 51AG of the Constitution of India, the judgment recognized corporations as legal persons and vital organs of society that share the fundamental duty to protect and improve the natural environment. CSR expenditure, particularly towards environmental protection, is thus elevated from the matter of benevolence to the faithful discharge of a constitutional and statutory mandate. Now, as we reach the home stretch, as the racing enthusiasts would say, what are the solutions that we can think of apart from our individual contribution? In 2 articles of great eminence published in a leading newspaper, jointly authored by 3 experts, Navroz Dubash, Shibani Ghosh and Aditya Valayathan Pillai, the authors stress the need for clear legal foundation to enforce climate rights. So there is a clamor for climate law. These are experts speaking. I mean, experts will have to look into it. It's beyond my ken to suggest one way or the other, but what the experts are talking, we must be cognizant of. They lay out institutional design ideas for a domestic climate law that would enable coordinated climate action by proposing mechanisms such as a low carbon development commission. So there is a need, they say, for a climate change law, for a low carbon development commission, some kind of a climate change commission, which would only study these aspects and make periodic recommendations, because they say as early as 2030, we could enter the danger zone in terms of rising temperature. This idea is not to create an alarm. Idea is only to create an awareness so that we all work towards mitigating it. A climate development commission, a climate cabinet for strategic oversight and strengthen federal engagement to support both mitigation and climate resilience. Other countries have had it. they say. And they suggest two models, the English model and the Kenyan model. And they advocate for following the Kenyan model because we are still in the stage of, on the anvil of becoming a fully developed state. So we need some allowances. So these are the things which one needs to think of in terms of the statutory framework. They opine that climate law cannot be understood only as a system of top-down targets, particularly in a developing country where climate change is inseparable from development choices. It requires constant legal and policy judgment about how growth decisions interact with long-term, low-carbon and climate-resilient pathways. Real action against the harms of climate change would depend on clear legal procedures that guide decision-making across all levels of government. Ultimately, climate action gains credibility when strong institutions are quietly doing the work of planning, prioritizing, and evaluating policy over time. From a constitutional law perspective, it can be said that the Constitution of India was drafted in a time when the sky was blue and the rivers were clear. But the wisdom of the drafters was such that they created a document capable of weathering storms they could not foresee. But more importantly, I want to go back to the words of the International Court of Justice, which has emphasized a complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge. Climate change is not a problem for governments alone, or courts alone, or scientists alone. It is a shared test of who we choose to be together. Educating young children about climate change, catching them young. No doubt these days some aspects of environment mentioned, but the idea is to create a culture of, awareness of climate change, a culture for environment protection. In an important step towards building a society that can respond to issue in a collective and informed manner. When climate education is introduced at a formative stage, it promotes long-term understanding rather than reactive responses later in life. The science tells us what is happening. The law tells us we have a duty to act, and history will tell us whatever we did, whether it was right or wrong. Real solutions demand collective action from every corner of society. Leaders who are brave, businesses that are responsible, communities that are engaged, and individuals who refuse to look away. Climate change may be global, but action is personal. And if we move together urgently and deliberately, we will have the power to shape a safer, fairer future. Thank you very much for your patience this morning.
If anybody in the audience has any questions, you can ask, but please be brief, please be specific. No rambling question. Okay, or a comment without a question, as sir desires. Mic.
Good morning. My name is Sohan Hatangadi. I'm involved in environmental activities in Vizag. What worries me is that we have on one side government taking huge decisions, state government, union government. And on the other side, we have the people who are affected by these decisions. But whenever the government, local administrators have a meeting to discuss a large unit to be put up on our suburbs, the stakeholders are only those industrialists, and we are not involved. So we keep asking every decision you take on industrialization, which may cause pollution, you must have the stakeholders from the general public. Of course, you have the big meetings where you take decisions where the public are invited, but anytime the public make a little bit of noise about this in the pollution causing, or what they are afraid of a pollution causing business, they are kicked out of the hall by the police. The police are in cahoots with the big industrialists. So here is a situation where, despite our best efforts, we can hardly do anything unless the law makes it sure that the local people, the stakeholders, we who are getting coughing and having eye burning and nose blocking over here, get involved in that decision which says put up a coal crushing unit in some suburb of Vizag. Thank you.
Finish your question, please.
Namaste, Millards. I am Principal CBI Judge, Visakhapatnam. Just I want to say only one small thing. Regarding preservation of cultural heritage also, there is one landmark judgment of Honorable Supreme Court in Taj Mahal case, where the industries were forced to shut down, Milord. Just I want to share this experience. We have to preserve the cultural heritage also. Yes, Milord.
Respected Justice of the Dais, one thing is that we are all suffering in Visakhapatnam with the black dust, because we are all having so many diseases, particularly lung diseases are like that. But nobody go to high courts and Supreme Courts like that. So I request the Honorable Chief Justice, Honorable Justice, at least all the legal service authority has to take care of this issue in all the districts in India. This is my request to the Justice who are before me. Please consider it.
Namaste, sir. I am Professor Raju, Chancellor, Central University, Vijayanaram, former Vice Chancellor, Andhra University. Sir, we keep talking about environmental protection. We are always concerned with sound, chemical, air pollution, water pollution and all. But these days, there are a lot of electromagnetic emissions coming from various sources, starting from radar, televisions, cell phone, cell towers, cells and all. And is there any law to control them? Because they are also very hazardous. The research shows that these electromagnetic waves are creating a lot of cancerous problems if they are continuously under exposure. Is there any law to control that? I don't think I have not seen any law to deal with that. Thank you.
I think, Rajendra, there are already some existing locations which say the distances at which you should locate these towers which emit radiation, etc. The law is in its place. There are regulations, sir.
Unfortunately, the cell towers are still installed on the housetops, which are very
Cell
dangerous.
towers emitting radiation is not scientifically proven. There are judgments on that where the court called for records and did not find any scientific evidence to back the claims being made by people who, but yes, there are restrictions.
In fact, the electromagnetic waves are beneficial for human health.
You have a counterpoint also. Anyway.
Good morning and thank you. This is so much required for all of us here at Vizag. We are at a very, very sensitive topography that we have. But with all the depth in talk, one thing we all need is just common sense. We are really in need of that because for no simple reason, trees are cut. For no simple reason, geological, huge portions are flattened. Water bodies are filled with debris. We don't need laws, we need common sense. The one who's building it should realize it. I wish that awakens us, and that is what is most needed, especially in most of our countries and the world.
Good morning, sir. Vizag air quality is suffering drastically. It's competing with Delhi. So my my request is the Navaratna companies like HPCL, even the Pollution Control Board can't do anything to them. They should have a greater obligation towards protection of environment, and they should be governed more strictly. These PSUs are making hundreds of thousands of crores, and cities like Visakhapatnam are suffering. I don't have adequate data to substantiate my claims, but it's the popular belief in Visakhapatnam. There's no agitation in Visakhapatnam. People of Vizag are very docile. There's no strong public opinion, but we are suffering, sir. Navaratna companies need to be more accountable, and also they need to take greater measures, sir. The local pollution control board is not in a position to govern them and implement pollution control norms, sir. Thank you.
Thank you, sir, for a valuable and enriching lecture. We are fortunate to be part of this lecture. Now I request D. Karan, the grandson of our late D.V. Subbarao garu, to propose vote of thanks.
Good morning, everyone. Good morning, everyone. I thank you for your patience as we conclude this lecture. It's my honor to extend my heartfelt thanks in concluding this lecture. We're all very privileged to have such esteemed guests among us, especially Shri Justice K.V.VISWANATHAN garu. Thank you, sir, for taking out your time and giving us such knowledgeable insights in such an important topic. I would also like to extend my special thanks to Hon'ble Justice Chimalpati Ravi garu, to all the members of the Andhra Pradesh Judiciary, to the Center of Policy Studies and the Visakhapatnam Public Library for organizing this lecture, Shri Pattabi garu, Senior Advocate, Shri P.B. Suresh garu, Senior Advocate, Shri Vipin Nair garu, President of the SCORA, Shri Murli Neelkantan garu, Advocate, to all of the Vice Chancellors who have taken time to come for these lectures, to all senior members of the Visakhapatnam Bar, and all other advocates from the Supreme Court, High Court, and Visakhapatnam. I would also like to thank Ms. Shri Prabhu Kishore garu, Chairman Varun Group, and his management staff, and all my fellow colleagues and juniors from the Visakhapatnam Bar who have come together to make this event a successful one. I would also like to extend my special thanks to the media houses that have covered this event. Therefore, I thank you all once again for your presence and making this a memorable one. Thank you.